So we're thinking about negligence. And the questions we want to get through as we look at negligence are, what are the three things we've got to have to prove that there has been negligence? And who do we owe a duty of care to? And where does the concept of a duty of care come from? Because this is what's different for a tort compared to a contract. A contract says we've got an agreement in place. A tort says we've got a duty of care to other people, even if there isn't a formal agreement in place. Okay, here are the questions to proving negligence. And this is what you'd have to do, probably be at a C- level, right? Without anything else, you've got to prove that there has been a duty of care, that the duty of care has been breached, and you can prove that it's been breached, and damage has been caused. So if we go to the example that Wes talked about, it was a duty of a care to someone in a shop. So does someone working in a shop have a duty of care to the customers? Absolutely. You could find some cases, recent cases where that's the case. Has the duty of care been breached, and is there proof of that? You'd say, well, when someone made a mess on the floor, there's probably policies in place saying that's got to be cleaned up straight away. And there's evidence, of course, that someone slipped on whatever was dropped. So it does seem there's proof and there has been no breach of the duty of care. And the third thing there is, have damages been caused? Right? And the fact that their leg is broken is a subtle sign that all is not well. Okay, so there have been some damages. Now, here comes some really interesting history about where the duty of care comes from. One of the first negligence cases came when a person having a drink got sick after there was a slug found in their drink. And the basic idea was that there was a slug in a bottle, and it came down to the question of who do you owe a duty of care to? Because there wasn't a formal contract between the person who'd been in drinking the drink and those people who'd made the drink and had unfortunately allowed a slug to be in the bottle. So this statement becomes really important. You must take reasonable care to avoid acts and omissions, so it means taking care not to leave things out, which you can reasonably foresee would be likely to injure your neighbour. So this becomes a really important principle around negligence. Now here comes the first element. And this is where maybe we get to some B-level work in here. Right, we're saying more than just talking about whether a duty of care is owed, we're saying here's the test for a duty of care. Are the consequences of harm, damage reasonably foreseeable? Okay, so can we reasonably foresee that there is a relationship between something we're doing causing harm to someone else? Is there a closeness between the parties? Is it fair, just and reasonable that the law imposes a duty? So let's throw the hypothetical case here around a teacher and a wobbly fan in the classroom. So let's say I've got a wobbly fan in this classroom and I still sit students underneath it. Are the consequences of harm reasonably foreseeable? I'd say, yeah, if you know that a fan's not working properly, and if the fan falls, it's going to hit someone pretty hard, that's pretty foreseeable. Is there a closeness between the parties? Is there a closeness between a teacher and a student? There is. And is it fair, just, and reasonable that the law imposes a duty? I suggest that they would say, yeah, absolutely, because we want teachers to be thinking very carefully about how they can keep students safe in situations like that. So there you go. That would be the first element. That would be how you would discuss duty of care. The second question I've posed there is around whether someone at Woolworths owes a duty of care to a customer in Caboolture. So does a worker at a Woolworths store in North Lakes owe a duty of care to a Woolworths customer in Caboolture? And clearly I'm looking at here is saying, is there a closeness between the parties? Let's say, for example, they were packing up some mayonnaise. And some of the bottles were broken, but they just left the broken bottles in the back end of the mayonnaise. So when the mayonnaise got from North Lakes to Caboolture, some of that leaked on the ground and made the floor slippery. You'd say, well, are the consequences of harm and damage reasonably foreseeable? Yeah, probably are. If you've got broken mayonnaise that's possibly going to leak around the place, that's not good on those Woolworths type floors. Is there a closeness between the parties? That might be an interesting question. Right. Is there a closeness between a shopper in Caboolture and a store worker in North Lakes? Yeah, maybe, maybe not. And is it fair, reasonable and just that the law imposes a duty? I suspect they'd say, yeah, we need people to be careful with that. But that is another example there. Element number 2. Let's quickly talk through these. The ordinary person, the reasonable person is the test. Okay, what does a reasonable person say? And some of the things that the court would look at is, what's the degree of risk? Okay, if you're rock climbing, for example, and you know there's a high degree of risk, you've got to take more care. How practical is it to take precautions? There are some things that just end up remaining risky. Rock fishing is one of the most dangerous sports in Australia. But there's not a huge number of precautions you can take. You can take an EPIRB with you. You might try and have some harnesses, but there's not a lot you can do. The seriousness of the harm. So this is saying, well, if the rock climbing goes badly wrong, the harm could be significant. So it's really important that you take some precautions. And social importance of the risky activity. If it's socially important, there might be more reason to carry on with that activity even if there is risk involved. Okay, and that an initiation sort of rite of passage might be part of looking at that. Okay, oops. And the last thing, and we'll finish with this today. Jot this down, I'll get back to this. Let's have a look at this last slide. Key things here. The harm would not have occurred but for the action of the defendant. So it's got to have been, if you go back to the example of me mowing the yard and the rock goes up into the neighbour's new Jeep, would that harm have occurred but for the action of the defendant? If I wasn't mowing, would that harm have occurred? No, it wouldn't. The only reason they got stone chips down the side of the car was because I was mowing. And the remoteness of the damage. The damage cannot be too remote from the negligent act. So let's say, for example, like some of you guys are known for your fairly wordy assignments. All right, so let's say, I'd say, Olivia's right up there. How many words have you got, Phoebe? Finn, what are you up to? How many words for yours? Yours looking all right or a little bit long? It's okay. Finn shouldn't be looking at anyone. Finn's right in the firing line. Phoebe, how's yours looking? A touch wordy? Maybe 1700. Okay. So let's say I mark all... There's another one? 2000. Okay. Isabel's in there. So let's say I mark all those assignments and I'm tired at the end of it. Right? I'm tired at the end of it. And I'm ironing my shirt late at night because I like to be respectful the next day. And I burn my hand on the iron. Right? Can I sue those students who wrote longer than word limit assignments? And the question, I think you would look here at the remoteness of the damage, right? If I'm trying to say that long assignments caused me to burn myself on an iron, that's a fairly remote sort of a link to be making. So I don't think there's any real link there. We'll leave it there.